Buonasera, buon pomeriggio a tutti, benvenuti. I will switch to English, and today the AIA-CAM Book Club welcomes you with one of the most widely recognized procedural principles in international arbitration. That's the topic of today. We will be dealing with the parties' right to be treated fairly and to have also a reasonable, if not full, opportunity to present its case. So we will be debating on the key principles of procedural fairness that are represented, that are included in the notion, in the expression due process. Principles that are recognized in international arbitration rules, in international conventions, and as well as in many national statutes. So we will probably discuss limits, boundaries to the due process, making reference to recent trends or all trends in the practice of international commercial arbitration. Well, I'm also welcoming you all also on behalf of the Milan Chamber, even if I noticed that Stefano Azzali and Andrea Carlevaris are also connected. And I'm glad to say that we are honored to include in the book club events the excellent work of Professor Franco Ferrari and Friedrich Rosenfeld, the due process as a limit to discretion in international commercial arbitration. Well, today's speakers are so well known that to the Italian arbitration community that they do not need an introduction. But of course, I cannot be an anarchist and ignore formalities. So I will start briefly presenting the authors of the book that will be discussed today. So let's start with Franco. Franco Ferrari is Professor of Law, Director of the Center for Transnational Litigation, Arbitration and Commercial Law, based in New York. Franco has published a very large number of law reviews, articles, and books in various languages in the areas of international commercial law, conflicts of laws, comparative law, and international commercial arbitration. His co-author is Friedrich Rosenfeld. Friedrich is partner at Rosenfeld, based in Hamburg. He has a wide experience in international law and international arbitration law. He has acted as arbitrator under the rules of different institutions, and as counsel, he has represented private parties and states. The role of discussant today will be played by Laurence, and I'm pretty sure that he will highlight a number of critical points on due process. Laurence Shore is of counsel at Bonelli Erede in Milan. He's a counsel, he's an arbitrator, he's an author of law articles and books on investment arbitration law. Has a wide experience in international arbitration, both commercial and investment, and also in international law. And then before entering into the depths of the discussion, we will benefit from, I'm sure, brilliant introductory remarks on such an important topic by Domenico Di Pietro. Domenico Di Pietro is partner at GST, London and Miami. He's authors of articles and books, one focused on enforcement of arbitral awards, co-authored by Emmanuel Gaillard. He has a large experience as arbitrator and counsel in many different sectors. So this done, recommending the participants to use the chat if they want for questions, or otherwise raising their hands, considering that all the questions will be answered at the end. And also recommending to keep the microphones closed. I wish to thank speakers once again for accepting this invitation. And I'm really, truly delighted to open the webinar and leave the floor to Domenico Di Pietro.
Thank you, Maria Beatrice, for the kind introduction, and certainly for inviting me to introduce our meeting today. The book is, of course, a welcome addition to the small handful of books that are focused on what I would venture to describe an existential issue of international arbitration. What I really like about the book, and particularly about the authors, is that they have the ability to identify topics that really matter and have the courage to analyze the topics with the integrity and the openness that you would expect from professionals of that caliber. I also add one thing about the other discussant today, Larry Shaw, and you correctly said that, you know, leading counsel, top arbitrator, and author of leading publications. And as far as I'm concerned, Larry Shaw is also the author of the best book review I've ever read in my life. And coincidentally, a book on a topic not far from what we are discussing today. But having said that, going to our topic, as you just mentioned, Maria Beatrice, due process is, of course, a core element of any credible means of dispute resolution. And as the author suggests, due process is an umbrella concept covering various guarantees of procedural justice. I have seen the term concept used for due process several times in the introductory chapter of the book. And if we have time, we could ask the authors whether we should define due process as a principle rather than a concept, bearing in mind that a concept is an idea not yet accepted as a universal value, while a principle is a standard of value that is established and as such respected and enforced, so that concepts are the building blocks of principles. Of course, I do not wish to waste our time with a discussion of little consequence, but there is no doubt that due process, which is very rarely expressly defined in treaties, is the catalyst of the legitimacy of international arbitration. Now, you mentioned, Maria Beatrice, international legislation, treaties. If we look at Article 5 of the New York Convention, which is almost verbatim reflected on the ancestral model law, due process is at the basis of the closed list of grounds allowing for annulment of the award at the place of arbitration or refusal of enforcement when enforcement is attempted abroad. And the book identifies the four main elements of due process, such as the right to be heard, the right to equal treatment, obligation to ensure proper notice, and independence and impartiality of arbitrators, of course. There may be additional or ancillary declinations of the principle, but I agree that those are the main elements. Of course, due process plays a role in public international law, an area of practice that our speakers today are well versed on, and under public international law, due process is the embodiment of the minimum standards of justice that guarantee the right to a fair trial. And as is also well known to the fans of investment arbitration, several BITs identify due process as a constitutive element of the fair and equitable treatment standard, and the 2012 US model BIT defines fair and equitable treatment as including the obligation not to deny justice in criminal, civil, or administrative adjudicatory proceedings in accordance with the principle of due process embodied in the principal legal systems of the world. So this is, of course, the magnitude of what we are talking about. And but going back to the book analyzes due process with the declared objective of establishing, among other things, whether and to what extent the so-called due process paranoia is justified. And there are several references in the book to the definition of due process paranoia offered under the 2015 Queen Mary International Arbitration Survey, where the due process paranoia is described as a perceived reluctance by tribunals to act decisively in certain situations for fear of the arbitral award being challenged on the basis of a party not having had a chance to present its case fully. Now, one may add for fear of the tribunal itself being challenged based on the alleged breach of due process. But what we have, so in a due process scenario, due process paranoia scenario, we have a tribunal that makes case management decisions that are overly deferential to the procedural wishes of one of the parties, under the misguided perception that such level of caution is necessary to avoid the risk of the award being challenged. Unsurprisingly, parties frame their procedural requests and complaints as a matter of due process to somehow maximize their chance of a favorable procedural outcome. By doing so, they force tribunals to overthink and overreact and put in place practices that are unnecessarily cautious and most of the times inefficient, especially because we know that arbitral tribunals enjoy ample powers. And these are powers that are broader than the powers that arbitrators are prepared to exercise. And the authors suggest, they will correct me if I misread what they said, and that by surrendering to the due process paranoia, arbitral tribunals thereby put the very hallmarks of international arbitration at risk. It's very difficult not to agree with this. But this passage is interesting because it leads me to one additional concern analyzed in the book, which is the following. This paranoid manifestation of due process clashes with the expected efficiency of arbitration proceedings, of course. And the book, of course, finds that the two goals are not mutually exclusive, but complement each other, so that it is perfectly possible to maintain high standards of due process while at the same time running arbitration proceedings efficiently. But we should bear in mind, of course, that efficiency is aspirational in nature and can only be attained with the agreement of the parties and the proactive participation of all stakeholders. Efficiency, however, is not a binding principle. Due process is. There is no justice without due process, no matter how fast the arbitration go. And this is an important conundrum that is stressed by the authors throughout the book. As to the structure of the book, the authors requested leading scholars and practitioners to prepare country-specific reports focusing on the notion of due process in their jurisdictions. And the report is composed of two parts. The first part discussing the general framework of due process in international commercial arbitration, and the second part addressing the description of due process issues in practice and the concerns attached to the four main categories of due process instances that I described a while back. So I don't want to take too much of our time today because I'm very eager to listen to what our authors and Dr. Larry Shaw had to say about this. But I would like to leave you with two questions that maybe we may address if there is time. and whether the report confirms that this so-called due process paranoia is unjustified, and also an issue of threshold, because of course not all procedural breaches, even if established, justify a code for lack of due process. Only severe breaches would justify such a call. So I would imagine that the threshold is placed at the different level across jurisdictions, and it would be interesting to see whether there is a detectable trend throughout those jurisdictions that will help us identify some kind of minimum standards or higher thresholds depending on the circumstances of the case. In any event, I would like to close my introduction to thank you again for this opportunity, and also to offer my heartfelt congratulations to the authors on this wonderful achievement. Well done.
Now,
Thank you, Domenico. Shall we move now? I would rather give the floor directly to Larry Shore. Larry, are you ready for that?
I think so, Professor Deli. Thank you very much, and many thanks to Domenico, because I think he's made my role somewhat superfluous by giving such an outstanding introduction. I want to make sure everyone's seen the book, which is, I fully endorse what Domenico said. I think it's a great book. And in particular, I want to echo what Domenico said about the optimistic tone of this book, because what Professor Ferrari and Dr. Rosenfeld, I think, have done is beautifully navigate the tension in the role of an arbitrator, the dual role of an arbitrator as a justice giver on the one hand and a service provider on the other. And I think Domenico said it extremely well, and I think Professor Ferrari and Dr. Rosenfeld wrote about it extremely effectively. And just so everyone's on the literally the same page, as justice giver and service provider, I'll just quote Article 17 of the UNCITRAL arbitration rules. Subject to these rules, the tribunal may conduct the arbitration in such a matter as it considers appropriate, provided that the parties are treated with equality and that at an appropriate stage of the proceedings, each party is given a reasonable opportunity of presenting its case. Justice giver. The arbitral tribunal, in exercising its discretion, shall conduct the proceedings so as to avoid unnecessary delay and expense and to provide a fair and efficient process for resolving the parties' dispute. Service provider. And I think Domenico has already described that. The process I will follow will be to pose questions to each of the authors, and I'm going to specify the author that I'd like to answer first, and then if they don't like that, the other author will jump in, and they can certainly add to each other. And I should mention that that Professor Ferrari and Dr. Rosenfeld have co-authored the general report that Domenico referred to, which sets the stage for the country reports in the book. Dr. Rosenfeld also authored the country report for Germany. And I think the book is so effective because the general report really is a beautiful summary and extension of the country reports on which it relies. So with that, I'm going to jump right in with a question for Professor Ferrari, and it's a compound question, but hopefully it won't be objected to. And Franco, is there a uniform concept of due process? And related to that, here's the compound part. What's the normative basis of due process that you and Friedrich have set forth in this tome?
No, thank you. Allow me to address Larry's normative point first, because I think it answers also the question of whether there is a unitary concept of due process. Now, as for the normative basis, it is not easy to identify. Why? Because express references to due process in the various arbitration statutes or laws are rare, if not lacking altogether. We have seen, and Domenico has referred to some exceptions in a BIT. Now, allow me to give a prominent example of where no such reference is to be found. The New York Convention. The New York Convention does not at all mention the concept of due process. Rather, it creates a regime for the recognition and enforcement of foreign arbitral awards. We know, in fact, that under this regime, states may be entitled to deny legal effects to awards that have been rendered in breach of procedural guarantees, of course, which are but a manifestation of what we in our book call due process. But similar to the New York Convention, many domestic arbitration statutes do not reference at all the concept of due process. Now, this certainly holds true for the various jurisdictions that have implemented, transplanted, adopted the UNCITRAL model law, which in effect also does not expressly mention the concept of due process or any due process guarantees, at least not expressly. What it does is to contain a robust regime, so to speak, of procedural guarantees that can be seen as manifestations of due process, of course. Here, probably most notably, one should refer to Article 18 of the UNCITRAL model law, requiring arbitrators to treat, and this was mentioned before, parties with equality and to give each of them a full opportunity of presenting their case. And this provision is to be considered, and I think we mentioned it in the paper you refer to, mandatory, meaning that states may not derogate from this upon implementation in a domestic arbitration. But one finds similar due process guarantees in arbitration laws that are not modeled or based on, modeled after or based on the UNCITRAL model law. And here allow me to give an example from French law. Article 1510 of the French Code of Civil Procedure provides that, and I'm basically paraphrasing, irrespective of the procedure adopted, the arbitral tribunal shall ensure that the parties are treated equally and shall uphold the principle of due process. So this is a translation, and I'm not sure the words actually refer to due process is in the translation, the original, because their reference is made to principe du contradictoire, better translated, and we know it even in Italy, as a principle of adversarial process. The same principle features, and the Italians among us know it, in Italian arbitration law, in effect in Article 816 of the Code of Civil Procedure, pursuant to which arbitrators must respect in any case the principle of adversarial process by guaranteeing both parties reasonable and equivalent opportunities to present their case. Now, I could go on and refer to other provisions, of course, and I could refer to the English national report, which Friedrich and I in our general report refer to. But basically, this is to show that the normative basis for a reference cannot be normally found. What we refer to is a concept, and Domenico asked the question earlier, why we labeled it, because we use the term as a concept, meaning as an expression. to label entire classes or categories of situation which do share the same characteristics. In this sense, we use the concept as a means of tying together these situations for the purpose of understanding them and their relationships better. I hope this answers the question, and it shows that, of course, there is not really a unitary concept. Also, there are common traits.
Thank you very much, Franco. Friedrich, did you want to add to that before I pitch a question to you?
No, I very much agree with what Franco has just said.
Thank you.
That's a good start for the co-authors. Let me ask you, Friedrich, then following on from that, how are due process guarantees to be interpreted? What do you and Franco find, in particularly in looking at the country reports collectively, and what you concluded in your general report about how due process guarantees are or should be interpreted?
I think, Larry, as a starting point, we have just heard from Franco that due process, whether you label it a concept or a principle, is a catch-all term that covers various procedural guarantees, some of which have their basis in domestic statutes, others in a treaty. And so you won't be surprised to learn that the interpretive approaches vary depending on whether we look at a treaty or at a domestic statute. It's crystal clear that a domestic statute must be interpreted based on domestic standards, whilst a treaty should at least be interpreted based on autonomous standards, even though sadly courts do not always do this. Now, if you hear this, you would expect a very diverging approach to due process across jurisdictions, because we have multiple domestic sources that are interpreted based on domestic standards. But the finding we make in our study is that there is a considerable degree of convergence in the interpretation of these due process guarantees. And let me just mention three trends we can identify. First, many courts say, well, we must interpret the grounds for set-aside and for refusal of recognition and enforcement narrowly, and we may not use due process as a pretext to enter into a review of the merits and to reassess the arbitral award. Second, many courts have said, well, even if we're applying domestic sources, we must do so with due respect to the international nature of international arbitration. If you look at the restatement third, for instance, in the United States, there's a remark where the drafters say, well, we do not yet have a truly autonomous international standard in the United States, but we are willing to tailor our analysis to the needs of international arbitration. And we also appreciate that international arbitration is not litigation, and that if parties arbitrate, we cannot apply our concepts and standards, principles, however you call them, that we know from domestic litigation proceedings as a benchmark to assess what's going on in arbitration proceedings. And third, and this actually brings me to one of the questions that Domenico raised earlier, courts across the world have applied a threshold in the administration of due process guarantees. Domenico, you already raised this question, and the clear answer is yes, that's a trend we see in the interpretation of due process standards. Now, how is this threshold defined? The precise tests vary across jurisdictions. In some jurisdictions, courts would make an assessment of whether a due process breach was outcome determinative, or at least could have an impact upon the outcome of the arbitration. Others say, well, the test is whether a party suffered prejudice or whether there was a grave or serious violation. The way the tests are phrased differ, but overall, we see this approach of courts saying, well, there must be a threshold. Not every minor infringement justifies a post-award remedy. And this, of course, very much makes sense if we come back to the dichotomy between arbitrators as justice givers and service providers. If we look at the goal of securing the efficiency of the proceedings, this is a tool to prevent that minor irregularities cancel the entire award, and it's in fact at the post-award stage. So it is very much conducive to the efficiency of arbitration. And I think those are three trends we observe in our study as far as the interpretation of these due process standards is concerned.
Thank you, Friedrich. Franco, I wonder if you would stay with that that point on post-award review that Friedrich was outlining, and if you could discuss what you and Friedrich found about the standard of review that courts do apply, should apply at the post-award stage on the due process guarantees that that Friedrich was describing. If you could go into standard of review a bit more, I think as you both do in your general report, I think that would be very helpful.
Now, if I get the point, so what you're asking me is to look into whether at the post-award stage courts may assess actually independently whether arbitral tribunals observe due process guarantees or actually whether they pay some kind of deference to previous decisions. Now, for the purpose of this answer to you, Larry, but this also holds true, of course, for the book, allow me to define deference as the attitude by which a court in any given way, one way or another, follows, again, in one way or another, a determination made by a different decision maker and reaches actually a conclusion it would otherwise not have reached, had it, of course, decided the same question that we are talking about independently. Now, according to this definition, and again, it is in the book, questions of this type of deference only arise where a certain subject matter is subject to review in the first place. And our general report shows this. If a court does not review an arbitral award on the merits, this, of course, according to us, is not a matter of deference. It cannot be a matter of deference, but this is due to the limited scope of review at the post-award stage mentioned already twice today. Now, many country reports included in the book do show that courts are willing to follow determinations made by arbitrators. And this, in my opinion, is an important point. Let me give an example. The US report notes that due to the strong public policy favoring arbitration on both state and federal level, courts are highly deferential to arbitrators' determinations or decisions. Similarly, courts in Singapore have paid indeed considerable deference to the broad case management powers of arbitral tribunals. There is one case we highlight also in our general report, Triulci Cesare SRL, but also in the Singapore report, where the court noted that the tribunal had balanced its obligation to grant a reasonable opportunity to be heard with competing interests to actually expedite the proceedings, something mentioned by Domenico earlier as well, and save costs or to offer confidentiality protection to a third party. Now, in that case, the court held that its review should be concluded with a light hand. And courts in many other jurisdictions refer to in the book, in the national reports, adopt a similarly differential approach in reviewing actually whether due process guarantees were upheld, whether due process was granted. They have characterized sometimes their role as that of overseer, which should not, however, second guess an arbitration award. It would be wrong to conclude that all courts, however, observe the same standard of deference for whatever issue may arise at the post-award stage. This is not true, and again, our book shows that. Now, the level of deference appears to diverge, and this is, in my opinion, unsurprising, and it is determined by various factors. And again, the Canadian report would be a good example, because in Canada, there is support for the proposition that jurisdictional decisions are subject to a standard of correctness, while other decisions are subject to a standard of, if I remember well, reasonableness. Now, in light of this standard of reasonableness, courts show some form of deference in reviewing whether an arbitral award breaches due process or not. Canadian courts have justified this type of differential approach with the need to show respect for the capacities of foreign, actually, and transnational tribunals, and of course, sensitivity to the need of the international commercial community and the international commercial system as such for predictability in the resolution of disputes. Now, I could go on and of course show that the applicable level of deference appears to differ in some countries depending, for example, on whether the applicable provision of the arbitration statute or arbitration law is actually phrased as a broad standard. Because if it is phrased as a broad standard, that provision would give tribunals some margin for discretion. And of course, it would be harder for a court to second guess an arbitral tribunal's determination in the exercise of that discretion. So to make a long story short, I think the various reports really show that there is a different treatment, but deference is often given to certain type of decisions.
Many thanks, Franco. I'd like Friedrich to stay with this point about what courts might look at, but in a specific context of parties perhaps waiving due process guarantees. And one argument that is made that arbitral tribunals shouldn't be so worried about or shouldn't be paranoid about come back to paranoia, because once you use the word paranoia, you know it's not justified. But that tribunals shouldn't be worried because courts take the view that just by going to arbitration, parties have effectively waived certain due process guarantees that they'd have in court. And so that the whole idea of parties being able to come to court and argue about a denial of a reasonable opportunity, for example, to put their case, is suspect from the beginning, because they've gone to arbitration. There are no strict evidentiary rules. It's everything that is decided between the parties and the tribunal. So in that context, can parties waive due process guarantees? And in effect, have they already done it by entering into arbitration? And as you and Franco and I think Domenico in his excellent introduction pointed out, that if the parties have already presented themselves in a in an arbitral setting, and you have a principle and you have a goal, the principle being due process, the goal being expedition, but the principle has already been transformed because you're not in court, you're in arbitration. Should arbitrators be that concerned?
Larry, let me answer this question in two steps. The first sub-question is, can parties expect the same procedural guarantees that would otherwise apply in court proceedings, or do they waive them by agreeing to arbitrate? And the clear answer is parties cannot expect the same procedural guarantees that would otherwise apply in court proceedings. And if you will, yes, they waive them, they give them up. And there's clear case law saying this, that we do not apply the standards that would otherwise apply in court proceedings as a benchmark when we look at an arbitral award at the post-award stage. The benchmark we apply are the precise procedural guarantees that Franco already mentioned. Under the New York Convention, it would be the right to be heard, the right to equal treatment, proper notice, independence, impartiality, and so on. Now, a separate question is, with respect to these guarantees that apply in arbitration, let's say the right to be heard, right to equal treatment, can parties waive those guarantees? That's a separate issue. And the answer to this second question very much depends on the approach taken by a given jurisdiction. It may depend on the timing of the waiver, on the specific guarantee that is waived, on whether the waiver is limited to set-aside proceedings or whether it extends to recognition and enforcement proceedings. But despite all these differences, there is commonality across jurisdiction that when a party fails to raise an objection during the arbitration proceedings and thereby prevents the tribunal from curing an irregularity that has occurred, the party may thereby waive this specific infringement as a ground for post-award review, or you could also say it is precluded from bringing this procedural infringement at the post-award stage. Why is this so? Well, as I mentioned, the idea is tribunals shall be put into the position to cure an error. It's again an efficiency considerations, and courts have referred to the prohibition of contradictory behavior, the principle of good faith, the very purpose of arbitration to facilitate an efficient resolution of disputes. And so this is an approach we find virtually across jurisdictions, that parties waive their rights if they do not take action during the proceedings. In practice, this may, of course, sometimes be difficult. It may not be so easy if you have a distinguished panel of arbitrators before you, and you do not want to offend Professor Ferrari, who is your president, and you do not want to raise an objection by somehow questioning his authority. Who would ever do that, right? And there is, interestingly, case law dealing with precisely this question. In one German case, which did not concern Professor Ferrari, the arbitrator fell asleep during the proceedings. And at the post-award stage, the party said, well, this obviously could not happen. The arbitrator fell asleep. That's a breach of my due process rights. And the court said, well, you should have raised an objection. And politeness is not a ground not to do so. So if you decide not to raise a challenge, well, bad luck. That's the consequence now that you're precluded with this ground at the post-award stage. And I think this is a key takeaway of our study, that across jurisdiction, whatever like academic approaches to waivers you ultimately adopt, there is quite common ground that if a party is in the position to raise a challenge during the proceedings, does not do so, it will be prevented from raising this issue at the post-award stage.
That's great, Friedrich. Let me ask you 2 points about that before I turn to Franco again. Because I find this waiver issue fascinating, and it relates to one of the examples you've given. You know, many arbitrators, actually not many American arbitrators, but many European, Latin American, Asian, everyone but American arbitrators, sometimes at the end of a hearing will say to the parties, as we've come to the end of the hearing, the tribunal would just like to confirm that you've had the procedure of the hearing has been satisfactory and you've been able to present your case. Based on what you've just, I think, taught us, it's dangerous to accept that. I'm not sure that parties should be in a position of having to accept that or define an objection at the end of a hearing. Would that be a waiver if, in what you and Franco have looked at, if a party just passes on that and says, well, I will, I'll rely on the record, or I'd have to take instructions, the coward's way out. But what do you do in those circumstances if waiver, as you have, I think, rightly described, is a real possibility in many court post review assessments?
You're right. It is a risk for a party if it confirms that it does not have any objections regarding the other two proceedings. But if a party actually, it does not suffice only not to say anything. You really have to raise the objection then, right? In a way, you could say that the question by the tribunal does not add anything. It just puts it on record, whether the tribunal asks or not. If a party has an objection, it must raise it and say, look, this is what I'm unhappy with. This is why I think I did not have sufficient hearing time and I could not exercise my right to be heard, and so on. So I think that is really what a party needs to bear in mind. If it wants to raise a challenge at the post-award stage, well, it has to take action and should positively raise a challenge. It has to do so in a certain time frame, of course.
And let me ask you one more related waiver question. Reasoned award. Let's say the parties decide, and Franco, I'd like to come back to you on this as well. Let's say parties decide, we don't need a reasoned award. Have they waived their due process guarantees in those circumstances? Because the only thing you're putting forward to a reviewing court is the award, which won't have reasons. I mean, should parties recognize that when they don't, or when they agree, for example, to get a quick result, to say we don't require reasons? Are you not then waiving due process?
You might waive the right to have a reasoned award, but you might not waive all other due process rights you have. So the mere fact that you waive a right to have a reasoned award and you give up the right to see the reasons does not mean that you give up your right to be heard or that you want to be treated unequally. I think you really have to make a distinction in that respect.
No, thanks, Friedrich. Franco, did you want to come in on waiver at all?
Yes, on this last point, on your last question, Larry, because in fact, if you look at the AAA commercial rules, actually there, the award is not a reasoned award by default. So if your question had to be answered positively, then the choice of AAA commercial rules would always mean that there is a waiver. So I would agree, of course, with Friedrich's assessment that you may have actually waived the right to a reasoned award. And as an arbitrator, if I operate, and I do sometimes operate under AAA commercial rules, I still render a reasoned award. Why? Because I'm only involved in international arbitrations under the AAA commercial rules, meaning that I know that unreasoned award in certain jurisdictions cannot actually be enforced. So as an arbitrator, having the obligation of means, of course, to render an enforceable award, I would think that you should still, as an arbitrator, consider reasoning the outcome in order to avoid non-recognition or non-enforcement, despite the AAA rules, default rules, so to speak.
Well, many thanks, Franco. Let me, I think Friedrich's touched on this, but I wonder if you could expand on specific manifestations of due process that you and Friedrich, especially in putting together your general report, and in reviewing the country reports, decided were the ones that really arbitrators and counsel should be most attentive to?
So I've answered the question in a lengthy way. This one will be a shorter answer. So in the book, we did focus, in fact, as you mentioned, on several manifestations of the due process guarantee, also mentioned by Friedrich, specifically the right to be heard, the right to be treated equally, the requirement of effecting proper notice, as well as that of respecting party agreement, for example, on the procedure. And of course, the need to ensure independence and impartiality of the arbitrator. Now, from the various country reports, as well as, of course, from our general report, it seems that we can state that the right to be heard is a manifestation of due process guarantee that has occasioned most comments as well as case law. What does this mean? This, in my opinion, in turn means that this is also the manifestation that counsel seems to bring up by way of ground for challenges most often. And what, in my opinion, the various national reports show, not always successfully.
I wonder, Franco, if you could, and well, I'd like both of you to speak more about what you found on various aspects of the right to be heard, and in particular, Franco, your last point, that is not always successfully, as you mentioned. I know that the country reports are very positive as a general rule on protection for arbitral tribunals against either a set aside or a challenge to enforcement on this basis, that a party did not have a reasonable opportunity to present its case to be heard. But is it in some way, though, still a kind of a statistical issue that we just don't have enough statistical basis to say that there is, again, coming back to Domenico, that there is paranoia there, or whether it's a rational response to a real threat that arbitral tribunals should keep in mind. The country reports, again, I would say in my reading, and I know you've gone much deeper, you and Friedrich, they're very positive, but is the positive nature of those reports still lacking in your view? And you call for additional research in your general report. Is there still a statistical substratum that's lacking, and specifically on this right to be heard and the various aspects of right to be heard? And I'd like you both to speak about that, because it's such a big issue that you address in your general report.
Now, allow me to just refer to the statistics, and then I'm happy to give the floor to Friedrich on the right to be heard. Statistics are lacking. Why do I say that? Because we do not know how many arbitral awards exist. Some people make up numbers. If you look at certain statistics, these are made up numbers, because what we know is how many arbitrations are being initiated in any given year under given institutional rules. That's the only thing we know. We do not know how many settle. We will not know that. We do not know, and this is the worst, how many ad hoc arbitrations exist. So what we know is probably the number of court decisions, if there is a record, and there normally is a record, of cases being brought to a court in relation to an attempt to annul on a due process ground, such as the violation of the right to be heard. This is what we know. What we can say is that more often than not, statistically speaking, these efforts are unsuccessful. That's the only statistical evidence we have, but we do not know how often or how many of these arbitral awards are being attempted to be overturned, meaning challenged successfully, and so that we will not know.
Yeah, to complement this, I think our goal was not to be empirical in this regard and to do statistical research. I've seen recent initiatives to do such empirical and statistical research. One colleague in Germany did this for German court decisions, and I think in the Journal of International Arbitration, they also just had a new initiative on empirical research. That's not what we have done. What we tried to do with respect to the right to be heard, but also the other due process guarantees, is to identify the normative content or the dimensions, if you will. And as far as the right to be heard, we identified 4 dimensions. The first, very simply, parties have a right to make submissions and evidentiary offers in support of their case, a right which is not unlimited. And most importantly, courts across jurisdictions very clearly say a tribunal can set preclusive deadlines within which these submissions have to be made. Second, parties have a right to comment on submissions and evidentiary offers made by the opposing party, a right which is also referred to, and Franco mentioned this earlier, as the principe contradictoire, or the right of an adversarial process. And that is the idea. If something is brought on record by the opposing party, well, you have a right to comment on this. Within limitations, it's not an unlimited right, but that's kind of rule of thumb where something new is put on record. Parties might have a right to comment thereon. Third, parties also have a right to comment on certain findings of the tribunal. In the unlikely event that a tribunal engages in any independent fact-finding, which typically tribunals should not do, then a tribunal may not surprise the parties with these findings. Otherwise, it risks breaching their right to be heard. And this, by the way, also applies with respect to new legal considerations and concepts. There is a whole discussion of whether the principle jura novit curia or jura novit arbiter applies in arbitration. And I don't want to reopen this discussion here, but as I think common ground that if a tribunal comes up with a new legal consideration that the parties could not anticipate and that would otherwise surprise them, the tribunal must inform the parties and give them an opportunity to be heard. Otherwise, it risks breaching their right to be heard. And the fourth dimension, as a flip side of all of this, is that a tribunal also has a duty to consider and take into account the parties' submissions and evidentiary offers. So to some extent, the tribunal must engage with what has been brought forward by the parties. The idea is that the right to be heard would have no purpose if the tribunal could simply ignore what has been put forward by the parties. Now, in practice, this is of course difficult for a court exercising post-award review, because court may not review the merits and may not, say, reassess the evidence that has been assessed by a tribunal. So where do we really draw the lines? And that's difficult to say. I think the impression we get from the reports in our studies is that it is only in exceptional cases that courts have granted post-award remedies on the grounds that a tribunal failed to consider and take into account a party's submissions. One case I have in my mind concerned a case where a tribunal erroneously treated the parties' disputed submissions to be undisputed, and it then refused to take evidence on a fact that was relevant and material. And at the post-award stage, the court looked at this and said, look, dear tribunal, based on your own reasoning, this fact was relevant and material. I do not review this, but you yourself said it was relevant and material. In this situation, you would have had a duty to consider an evidentiary offer that was made by the party. Simply disregarding it altogether may constitute a breach of the right to be heard. And I think those are the four main dimensions of the right to be heard that we have identified in our study.
Franco, anything to add on right to be heard? I think that's fascinating, those four dimensions. Friedrich, Franco?
No, that was a very clear exposition of a much longer chapter in our general report, so I shouldn't add anything.
Before I dive, Franco, can you discuss then another aspect, equal treatment? Because I think that's one, along with right to be heard, which causes a lot of uncertainty for tribunals and gives counsel a lot of ammunition potentially to make an application, as you point out, may well be an unsuccessful application at a vacator or enforcement stage, but nonetheless one that will be there for the attempt.
Yeah. So, of course, the right to be heard, addressed by Friedrich just now, is closely intertwined with what you just referred, Larry, the right to equal treatment. Now, provisions such as, for example, Article 18 of the Untitled Model, which I mentioned earlier in the very beginning, and which references the right to be heard and being treated equally in one sentence, confirms this actually. And I mentioned it again earlier as well, the US restatement. The US restatement does basically the same thing when stating that all parties should be afforded broadly comparable opportunities to be heard. Now, the right to equal treatment requires the tribunal to uphold what is called the equality of arms in all matters of procedure. But I would like to mention one thing, that the right to equal treatment is not a right to identical treatment. Now, let me get back, however, to the equality of arms and refer to some of the aspects we have referred to and some of the national reports. French courts ruled, for example, that equality of arms, which is an element of fair trial protected by international public policies, this is actually French case law, implies the obligation to provide each party with a reasonable opportunity to present its case, including its evidence, and now it comes under conditions that do not place it at a distinct disadvantage relative to its opponent. So that's one view. The equality of arms, of course, entails that parties must have equal opportunity to make submissions, including, of course, evidentiary offers in support of their case, and to comment, as mentioned earlier also by Friedrich, on the opposing party's case. Now, where one party is granted the opportunity to produce evidence, whilst the other party is not granted such opportunity, this may indeed constitute a breach of the right to be heard, but only if the situations are comparable. This is also why I say that equal treatment does not mean identical treatment. Also, the applicable time limits for the party submissions should, of course, be administered equally under this umbrella concept, basically. This means that if both parties request an extension of a given deadline, but only one of such requests is indeed granted by the arbitral tribunal, this may and should probably constitute a breach of the right to equal treatment. As the various national reports show, courts will consider factors such as the nature and content of the submission for which the extension is requested when deciding on whether actually the right to equal treatment was breached in such a situation, and rightly so, let's add. And I could go on, and we make a lot of examples in the book. For example, when one party files a submission late, the tribunal nevertheless accepts it without breaching the right to equal treatment at times. But allow me to also point out that the reports show that not every form of unequal treatment constitutes a breach of the equality of arms. And this is important because, in my opinion, this also shows that the threat by counsel to have the arbitral award somehow rendered ineffective, either for annulment or because it will be or may be refused recognition and enforcement, is more often than not, and this is my theme today, an unsuccessful threat.
Franco, let me just ask on this, you've linked, I think quite rightly, equal treatment and opportunity to be heard. That is there any significance that in the UNSA trial model law, the term is full opportunity? So that in Article 18, which I think you referenced earlier, the party shall be treated with equality and each party shall be given a full opportunity of presenting his case. In your research with Friedrich and your review of the country reports, does it make any difference if you use terms in that way, say full opportunity, because it suggests something more, at least? I know other rules are very careful and other national acts are very careful not to say full opportunity, but when you're talking about model law, which is the basis for so many jurisdictions, does it matter, or is that just an excess of verbiage which courts don't really take into account?
No, of course, words matter, which is also why I did refer to other decisions or rules that refer to comparable and so forth. But in my opinion, this should not matter as a matter of equal treatment, rather the right to be heard. This is, in my opinion, where Article 18 is coming into play, meaning where that part which you just referred to of Article 18 is coming into play, rather than full equilibrium. That's not what it says. If we were talking about full equilibrium, then we would refer to the right to be treated equally and the equality of arms. This goes, in my opinion, to the right to be heard.
So I have two final questions, one for Friedrich and then one for Franco. So don't worry, Professor Deli, I will adhere to time. Of course, I can't control the witness and how long their answers may be. But here, Friedrich, I mean, I think I confess that in several arbitrations in my life as counsel, I thought, look, this procedural conduct of the chair or the sole arbitrator, it's really not fair. I'm not getting a fair shake in this case. And all I can do is say I lose every procedural application. It's done summarily. I have, not that there's a reasons requirement maybe for a procedural order, but I have only a procedural conduct which is, at least on its face, as I'm viewing that face as counsel, simply not giving me or my client due process. In what you and Franco have looked at, is it possible to challenge an arbitrator on that basis?
It's certainly possible to challenge an arbitrator. The question is whether the challenge will be successful, whether you should do it. And the answer is, in most cases, it will not be successful. The threshold for challenging an arbitrator based on his or her procedural conduct is very high. And why is this so? Well, again, that's the recurring theme today, because courts do not want to interfere too much with the way how an arbitral tribunal conducts the proceedings. And so there is a lot of case law saying, well, mere deficiencies in the procedural conduct of an arbitrator are not a proof of his or her lack of independence or impartiality. Also, sharing a preliminary legal assessment or making a comment has not been found sufficient to justify a challenge. Only where you really have egregious forms of misconduct. One example we looked at concerned an arbitrator who had secretly met with one of the parties and had conducted ex-parte communications on a relevant point. Well, then you have egregious conduct, and then it might be, you might have better chances of success of challenging an arbitrator. But overall, the threshold is quite high, and arbitrators must not be afraid. Sometimes I have the impression many arbitrators are afraid and say, well, if we do this, then we might immediately be challenged. I think they need not be afraid of such a challenge. It is only in exceptional cases where courts have found that conduct is a basis to successfully challenge an arbitrator, or then eventually an award based on the lack of independence and impartiality.
So it's good I haven't made that application then. Thank you, Friedrich. At least not that one. Franco, let me ask, and I don't mean to preclude you from this question, Friedrich. I'll ask it of Franco, and in kind of again compound fashion, and come back to what Domenico said at the outset. And then there may be questions from our colleagues. Is due process paranoia justified? Although keeping in mind paranoia is often like that's skewing it a bit, because it's hard to say that a paranoia view would ever be justified. But let me also ask you it in slightly different way. Given, as we all know, that in this process, we usually, maybe I can go beyond usually, or you and Friedrich may correct me, you almost always don't get an appeal on the merits. And on that basis, it is one stop. And whether, even if arbitrators have much more protection than maybe they have appreciated, because of paranoia being paranoiac. Even with that, should arbitrators given, as Domenico said at the outset, you're talking on the one hand about a principle, on the other hand about a goal. I think that's broadly what Domenico was saying. And given the lack of an appeal, a substantive appeal, even if, and you'll say whether the paranoia is justified, even if it's not justified, should arbitrators nonetheless, whether it's reasonable opportunity to be heard on the 4 points that Friedrich mentioned, or in the, I think, very clear discussion you gave of equal treatment not necessarily being or not being identical treatment, should arbitrators nonetheless, in that tension between justice giver and service provider, always be leaning, or almost always be leaning, to the justice giver position, which would mean more document production, more hearing time, more submissions, more opportunities, because in the end, the award is going to be it. So sorry for that lengthy introduction to the final question that I wanted to ask you both. But Franco, I wonder if you could take a crack at that.
Larry, if one considers paranoia as being, as it actually is, the irrational and persistent feelings that people are, so to speak, out to get you, or that you are the subject of persistent, intrusive attention by others. And in the setting we are discussing here today by the parties and or counsel, then I think today's presentation in our book has shown that the due process paranoia is just that, meaning an irrational feeling, as you also mentioned. We think that we have shown that arbitrators do not need to be as scared about their awards being challenged or not enforced, or them being challenged, because arbitrators do not seem to violate the due process guarantees as often as counsel seem to submit. So this would be, in my opinion, answer to your question. Even to the second part of the question, it seems that they are, the arbitrators, leaning towards the justice giver position anyway, because if giving justice means that your award is not being challenged for the grounds submitted by counsel, it means that you have already given justice.
Thanks very much, Franco. Friedrich, did you want to have also a final comment, at least for my questions?
Yeah, I think, Larry, to be frank, I cannot give you a precise answer as to whether arbitrators should lean towards their role as justice givers or as service providers, and potentially both. And it very much depends on the circumstances of the case. It's something a lawyer always says, but I think it holds true. And what we outlined today is, and what we outlined in our book, is that arbitrators have the authority to act in a robust way, and that they do not need to be afraid of the award being set aside or refused recognition and enforcement lightly. So they can, if they want to, reject the late submission that is made. They can reject the procedural request that is made at the 11th hour, and they will not risk their award. But of course, this risk of an award being set aside or refused recognition and enforcement is not the only benchmark for an arbitrator. And in a given case, an arbitrator may decide, well, it's maybe better to give a party the right to make another submission, even though it's not strictly necessary, but it might be conducive to the legitimacy of the proceedings. Or the arbitrator might also have in mind how the proceedings might potentially end. And I think that is something to also bear in mind, and that explains why I don't have a precise answer to you. Arbitrators have the power, but whether they make use of this depends very much on the precise settings of the case and the circumstances when a request is being made.
I should add, I think taking into account both of your points and Franco's, I think, eloquent statement that justice has been given, I don't want to create a false impression of what you get in the national courts, because of course national courts also say that they are there to be give efficient and expeditious hearings and process to litigants before them. So there's not an absence of a conception of service provider, I should say, in the national courts. And I think I was probably unfair then in describing a kind of ideal role there that might exist in the courts, which probably doesn't, at least not in many. For me, Professor Deli, that's been an incredibly useful discussion from the co-authors of what I do think is a great book, and provides tremendous guidance for both arbitrators and counsel. And I leave to your hands in the remaining few minutes about whether further examination should be required of the co-authors. I'm pitching it back to you, Madam Chair.
Okay, thank you so much, Larry. Really interesting, a lot of interesting points. Maybe, sorry, maybe we can open to questions from the participants. And in the meanwhile, I would also ask a comment from Domenico.
Yeah, with pleasure.
Well, please.
Yes. I just wanted to stress an aspect of our conversation today that I found extremely useful, and I think it could be a point of guidance. And this is the dynamic dimension of due process. And our conversation somehow helped us understand one element that emerged in addressing due process, which is the fact that parties cannot sit there and entertain due process as a passive right that they have. There is an element of interaction with the arbitral tribunal that was alluded to by Larry, especially when you get that very uneasy question as to whether you are happy with how the arbitral tribunal conducted the proceedings. And this is an element that is, I believe, is very important because it has an impact on the perception that eventually a domestic court would have as to whether I waived my right, as to whether the arbitral tribunal has been an opportunity to fix a perceived error in conducting the proceedings in an equal and fair fashion. So a degree of interaction, a degree of positivity that parties are expected maybe to acquire, put in place while dealing with potential issues of due process. And I very much like it. I conclude my small contribution, the example that Friedrich gave about the arbitrator falling asleep. And I had a conversation with a younger colleague a while back, and I said, if you don't want to raise an objection, at least you raise your voice, and that might fix the issue. Thank you.
Thank you, Domenico. It's I think we're almost close to the end of this webinar. So when there are no questions, either everything was very clear or was very complicated, and probably we do need to elaborate what has been said. And this, I think, is the reality. So let me thank Andrew. Andrew, there is one question. Yes, please step in.
As no one else has asked a question, I will ask a question given the fantastic presentations and very entertaining debate by all concerned. A premise at the beginning of the presentation was that there was, I think Larry used the term attention between a justice giver and service provider. But I noticed at the end when Friedrich was giving an answer and saying whether one of the parties should be given the opportunity to give let's say, make a further written or oral submission, even though it wasn't needed. And he justified that on the basis of, let's say, due process. That can also be part of the other side of the coin. That is the service provider aspect, because in fact, one of the duties of the tribunal is to satisfy the parties, surely, in providing the service. And so it may well be that there is not such a strict, let's say, tension between the two things, but they may also coincide. And it may be a very good reason to give the parties one further round or whatever, just so that the parties are satisfied with that let's say they have been given every chance to present their position and not end up with a feeling like Larry described, that the tribunal just dismissed every procedural application that he made. Perhaps someone has a comment on that.
Friedrich, you want, or do you want me to answer?
Please go ahead.
So the reference, Andrew, which Larry made, and also Domenico in the beginning, was a tension, if I'm not mistaken, between due process guarantees and, of course, working efficiently. So that's where, in my opinion, this came from. And I think that it is clear, and I think we wanted to make it clear at least, that yes, there is a tension. I think there is a tension for various reasons, sometimes, unfortunately, maybe self-interested reasons, but there is a tension. But I think they are not, and this is what we try to show, mutually exclusive. We are really talking about the possibility, of course, to have efficient proceedings, including, Andrew, in the case you mentioned, efficient means even for post-award reasons, it's efficient. Because if I give them a last shot, maybe I know already it doesn't change anything, but counsel is still happy, and therefore I'm cutting off possibilities to somehow claim something at the post-award stage. So this is really, in my opinion, the fundamental issue, which also, if I'm not mistaken, Domenico, you pointed out in your introduction. Now, you pointed, Domenico, to something that is very interesting. Due process should not be violated. If there is a tension, maybe one should err on the side of exceeding the due process guarantees, because if you don't, something will happen to the award. While, you know, you may be a little less efficient, more often than not a lot will happen, of course. Friedrich, did you want to add something?
I fully agree with your analysis, and I fully agree also with what Andrew has said. There are situations where a tribunal is not strictly obliged to give further, let's say, opportunity to comment, and should still do it just to satisfy that party and to act in a way as service provider. There is actually also one decision we looked at in our study, a French decision, where the due process goal and the service provider goal seems to overlap, and that's a decision of the Paris Court of Appeal, and just looked it up, where the court said, well, le fait pour les arbitres d'écarter les écritures tardives, loin de méconnaître le principe de la contradiction, on assure le respect. So in a way, the court said, look, in a given case, you may be required to reject a late submission in order to maintain due process. It's your duty to comply with due process to reject a late application. That's just another constellation where the goal to maintain due process and the goal to act as a service provider might actually overlap. So as I said, it's still a fact assessment that needs to be done, and in a given case, as you correctly mentioned, a tribunal might simply say, well, we don't care about due process, let them just, whether it's needed or not, let them just make another submission, and then we make everybody happy, and that might be the easiest solution.
Thank you, Franco. Thank you, Friedrich. I see there is Andrea Carlevaris. Andrea.
Yes, I'm sorry. I know it's very late, but I
will leave you to conclude. Also.
No, but when I hear about sleeping arbitrators, I can't resist the temptation of telling the story of this challenge against the arbitrator in question that came to the ICC court a few years ago. And the argument was precisely one of equality between the parties, because the allegation was that he would sleep, and he would fall asleep several times, but always during the cross-examination of one party's, the challenging party's witnesses. And the counter argument was that who sleeps by definition cannot be biased, which I think it's a funny anecdote, but I think it's back the interesting question as to how often breaches of due process are prompted by precisely conscious bias, and as opposed to sloppiness of lack of professionalism. Anyway, I think it's been really a great book club, really. I mean, a great seminar on a great topic. So congratulations to Franco and Friedrich on the publication of this great book. And also many thanks to Domenico and Larry for their excellent remarks.
Thank you.
Thank you for the invitation, first of all, really, I mean it. Thank you, of course, for the comments by Domenico first, and by Larry guiding us through many of the parts of the general report. So thank you very much, of course.
Great webinar. Thank you to all. Special thanks to Larry, who, despite a very bad and nasty cough, maintained his commitment to be with us. So thank you again. Thank you, Friedrich. Thank you, Domenico. And thanks to all the participants. See you for the next event.
Thank you very much. Bye.
Thank you.
Thank you. Bye.
Bye.
Bye. Bye.